But I think a confidentiality agreement is appropriate for any position that has access to customer information, customer lists. I think there's nothing wrong with a confidentiality agreement that prohibits workers who have that knowledge from disclosing that information after they leave.
This is the PMP Industry Insider Podcast.
Hello, everyone. Welcome out to another episode of the PMP Industry Insider Podcast, where we look at what is changing in the industry and take it to the front lines to those that are driving those changes. As always, I'm Donnie, Shelton, owner of Triangle Home Services, which has Triangle Pest as well as Triangle Lawn. And with me is Dan Gordon, Cy, and a fantastic guest. So, Dan, would you like to introduce yourself? Maybe not very long, maybe not as long as you usually do. And then spend a lot more time on our guest. And our topic.
Yeah, absolutely. So hello, everyone. Dan Gordon, PCO Bookkeepers, PCO M&A Specialist, Turf Books. And we cater to the pest and lawn industry for accounting services and exit planning services. And as our other episodes, this is sponsored by Coalmarch by WorkWave. To learn more about Coalmarch, go to coalmarch.com. And as far as a guest, today we're talking about hot HR topics, including non-competes, independent contractors, and exempt employees. And we are welcoming back for an unprecedented third visit, because when things change or when we want the answers, we tend to go to this guest as a go-to, and it is Jean Seawright of Seawright & Associates. I'm just going to read a sentence here. A human resource consulting firm that specializes in providing advice and solutions to clients nationwide to reduce their legal liabilities, enhance profits and productivity, improve morale, and ensure compliance with state and federal employment regulations. Jean's a frequent speaker at national trade associations, a columnist and author of numerous articles and publications in the field of HR, and she serves as an expert witness in lawsuits involving HR matters. Welcome, Jean. Great to have you.
Thank you, Dan. I appreciate that.
Yeah, you bet. So
let me just add that also we are a client of Jean's, and she has been fantastic for our business.
And we are thrilled about that and honored.
That is awesome. So probably a month ago, maybe 2 months ago, you could correct me, I saw something come down about certain proposed regulations to get rid of non-competes. And I figured it was time to call Jean and say, well, what does this mean to us? What does this mean to us as an industry? When we do M&A transactions, that's one of the first things that a buyer will ask. Do you have non-competes with all of your employees and whatnot? And I just wanted to get an expert's opinion on, number one, what does a non-compete mean? How does it differ from a non-solicit and non-disparage? And how could this, if this law were to go into effect, how would this affect us?
Can I give you a little background?
Absolutely.
On how we got here, just very briefly, because it does play a role in perhaps how this will end up. In July of 2021, the president issued an executive order, and it was entitled Promoting Competition in the American Economy. And that executive order directed the Federal Trade Commission, the FTC, to exercise rulemaking authority to curtail what he described as the unfair use of non-compete clauses that unduly limit a worker's ability to change jobs. So in response to that, you are correct, this past January on the 5th, the Federal Trade Commission published a notice of proposed rulemaking that categorically bans non-competes for all employees, all workers, and that is broadly defined because a worker under this rule, this proposed rule, would include both employees, independent contractors, interns, whether they're paid or unpaid. So it's a broad definition for the term worker. So we're dealing with a potential categorical ban on non-competes. And the thinking behind this is that they harm workers, they hurt competition, they reduce wages, they stifle innovation, and exploit workers. That's the philosophy behind the ban. And the FTC has predicted that if they eliminate non-competes, wages will increase for many workers, anywhere from 3 to 13, 14%. So they're bound and determined to see this through. If it's adopted, then employers in every state will be prohibited from using a non-compete clause. And to answer your question directly, a non-compete clause is a clause, we tend to refer to them as non-compete agreements, but the term used in the proposed rule is clause because the FTC knows that there could be a non-compete clause as part of another type of agreement, whether it's a severance agreement, a buy-sell agreement. There could be a non-compete clause in an employment agreement, a confidentiality agreement. So they use the term clause. So a non-compete clause is one that would restrict a worker from working for a competitor or starting a competing business within a certain geographic area and a certain period of time after employment. So that's what a non-compete clause is when they refer to a ban on non-compete clauses. A non-solicitation clause is an agreement where a worker would agree not to solicit an employer's customers for a period of time after leaving employment. So I won't go after your customers or maybe potential customers if I do leave the business and work for someone else. There are also
go after employees.
That's usually referred to as a no recruit clause. Some people call it no poaching, although poaching can have other meanings. But yes, that I would agree if I'm the employee and I leave you, I won't solicit or recruit your employees to work at my new company or the company I'm working at. So yeah, those are the differences. Now, this proposed rule, it bans non-compete clauses and other clauses that function like non-competes. So if a particular agreement, like a confidentiality agreement, is so overbroad that it has the effect of stopping an employee from working for a competitor, then it also would be prohibited. They're calling them functional non-competes if it functions like that. So an example of that would be if I'm a PMP and I have a confidentiality agreement, not a non-compete, but a confidentiality agreement where I say to you that you cannot discuss any industry business with a new employer. Obviously, that's overbroad, and that would stop me from working in the industry for a competitor. So that would function like a non-compete, even though it's a confidentiality agreement. So that's what they're talking about.
So
now this rule, if it was to go into effect, would also rescind all existing non-compete clauses that are in effect for current employees or former employees. So it has a rescission element to it that really, again, very, very broad. It's not just moving forward. It would be any agreement that's currently in effect. And it would, in fact, preempt all existing state statutes, regulations, orders, and interpretations that govern non-competes. And there are more than 30 states that have some type of limitation on non-competes. So they would all go away, and this would basically preempt all of that.
So prior to this, it was pretty much a state law thing. Each state handled it on its own. Does this affect that, the non-solicits, the non-poaching, as you said, do they want to do away with that? Because I get, you don't want to stop a guy from making a living if that's how he makes his living. But as soon as you touch my employees, as soon as you touch my customers, that's off limits. Is there any danger in that?
Again, only if those clauses or those prohibitions are overbroad. So they do have to be tailored in a narrow way, and they have to be specific to, just that information that is in fact confidential or a trade secret of the business, so that it isn't effectively preventing the person from going to work for a competitor. But you can still do it. And in fact, employers should do it. They should have been doing it all along. They should have confidentiality agreements or non-disclosure agreements, non-solicitation agreements. Thankfully, those would still be permitted, but again, they have to be written carefully.
And so just for anybody who's ever thinking about selling their company, not to bring this in, we have had deals fall apart because there were no non-competes or no non-solicits with certain employees. So it's extremely important that you think about this kind of thing well before you're going to make any move.
I know for me, like just thinking through the main thing I'm concerned about, I don't really care about someone like trying to stifle their career. I have no gain in that, but I'm absolutely want to make sure that they don't turn around and solicit my customers or my team. That's the part that I feel like we need to make sure that, I mean, especially if you're a PMP, that you need to make sure you're tight on that, because that's what I really care about. I mean, the non-competes, like whatever. I mean, I shouldn't say whatever, but just, so when I hear that, like, especially like a deal going through, it's that's kind of crazy. I've had similar experiences like that where people are very, very picky about non-competes, but I think the non-solicit is really, that's the real, in my mind.
That's the crux of it.
Yes.
Yeah.
100%.
And you're right, because when we talk to people about this, the first thing they'll say is, well, I don't want anybody leaving, solicit my customers. And so we'll point out, well, then why don't you just have that clause? Do you really need a non-compete? And it turns out that a lot of people have non-competes because they thought that was what it meant, was that you couldn't solicit the business, but you can still have those agreements, again, carefully worded, but you should have those, and that hopefully would prevent what everybody is trying to prevent, which is their business going down because somebody takes all their customers.
Well, there has to be some sort of protections, right, for the owner. I mean, at the end of the day, if you bring someone along, you train them, you spend a ton of money in developing those customers and developing that employee, and there's no protections for you. I mean, that's not really fair either.
Right. Mm-hmm.
I think in a high-tech company or something where there's something really that needs to be protected, that probably holds a lot more water. Pest control is pest control. And I don't want to, there are certain techniques that we use and whatnot, but most companies know, how to do it. So I'm not sure that the non-compete is as big of a deal, although correct me if I'm wrong. If somebody goes after my customers, somebody goes after my employees, that's where.
Well, it's not technology, right? It's relationships. That's the key in our industry. It's the relationship that, when that person transitions, because, let's face it, most people connect with a technician. They connect with someone who's an ops. They don't necessarily connect with the owner or the brand. So that's what really needs to be protected. So anyway, all right, let's keep going.
Yeah. And, let me just, to that point, the customer list is what's proprietary, right? Okay. And so that's the way those, you want to work with a lawyer, of course, on these things, because these are legal contracts that are only enforced via litigation. But the idea would be to define very clearly what is confidential information in your company. If you do have trade secrets, which is a very specific and clearly defined, or not clearly defined, but well-defined form of confidential information. If you have those, then you want to identify what they are. And that's, how to build out those agreements is clarify what is confidential information, what is proprietary, what are considered business, secrets or trade secrets.
So the FTC puts this out. Is it official yet? Is there a timeline for it? And then how likely is it to happen? Like where does that go?
So yes, the FTC has promulgated this notice of proposed rulemaking, and the public has a comment period. There's always a comment period once a rule is published. The comment period was scheduled to end on March 20th. However, last week, the FTC notified the public that they're going to extend the comment period to April 19th. To date, they have received over 17,000 comments. They've posted about 8,800 of those. You can go online and read them if you're so interested. But on April 19th, the comment period will close. The FTC will then consider the comments and issue a final rule that may or may not differ from the proposed rule. That can take a few months, obviously, for them to get through the comments and consider them. Once they do that, they will publish a final rule, and the final rule will not take effect before 60 days passes once it's published in the Federal Register. And then the way the rule is written, if this doesn't change, the proposed rule, the way it's written, employers will have 180 days from the point at which it's published as a final rule to comply. So, absent legal challenges that halt implementation of the rule, it will take effect sometime mid-2024.
Wow. And go ahead and get your crystal ball out. Let's hear, what are the odds?
Well, I do think they will publish a rule, and that's because of the executive order. When I first mentioned, the FTC has been charged by the president to implement a rule. And so I do believe that they will implement a rule. However, we anticipate that there will be immediate legal challenges, and there's a lot of talk about that already. And there's a number of good legal arguments to be made about the fact that the FTC has overreached its authority in promulgating this rule. So we expect to see those challenges immediately filed, and so that may put a stay on the rule. But there's another some interesting activity occurring on the legislative level that your listeners may not be aware of, and that is kind of an anticipation that the FTC rule will not stand. On February 1st. The Workforce Mobility Act was reintroduced in Congress. This had been introduced previously, I think 2019, 2021. This is legislation that effectively bans non-competes the same way the FTC rule would, with a few limited exceptions. So it's very similar to the Federal Trade Commission's proposed rule. The one difference is that it would not apply retroactively to non-competes that are currently in force. It would only apply to non-competes moving forward once the act is signed. So that is, Congress's solution to avoid this protracted litigation that the FTC is likely to face if they implement this rule. And I will tell you, there's bipartisan support, and a lot of people feel like, like you guys mentioned, that hey, we don't want to stop people from working in an industry or working in their profession. We just don't want them stealing our employees and our customers. So if enough bipartisan, senators and Congress people feel that way, this could pass, and that would have the same effect, basically.
So essentially, it's a regulation versus a law.
Correct. Mm-hmm. Yep. And, the FTC really, in my opinion, isn't in a position to enforce a nationwide ban. They've never done it before. It's completely outside the scope of hundreds of years of precedent in the way that non-competes have been enforced by the FTC. It's been case by case. So it does seem unusual that would be the agency doing it. However, I will tell you that in the Workforce Mobility Act, Congress explicitly gives authority to the Department of Labor and the Federal Trade Commission to enforce the law. So if it passes, then the FTC will in fact have some enforcement authority. They'll have explicit enforcement authority that they don't have now. So
I'm a PMP, and, I'm vaguely familiar with what's going on. I may have some non-competes. Who knows how up to date they are? I've been using it for the last 10 years, whatever. What should I be doing now? Like, how should I get prepped? It sounds like, and I'm not by the way, I have no official opinion that really matters on this, but it sounds like this is going to happen. This is probably going to go down. If they've got something in Congress and FTC has got something, and I agree with you, if the president says, hey, here's what I want you to do, even if it gets, lit up in courts, I think something is going to happen. What should I do as a PMP lawn care owner? Like, what should I be focused on right now? And how should I respond to what's going on?
So a few things, but one quick disclaimer, and that is, this is not legal advice. I'm going to give you some. I'll mention a few thoughts.
Our listeners are conditioned. They know that.
Okay, good.
They come to us for legal advice.
Okay. All right, that's my disclaimer for today.
Absolutely, knock it out.
So the first thing we're telling people is if you're in a progressive state, be on the watch, because we expect some of the states to adopt some categorical bans long before Congress acts on the Workforce Mobility Act and the FTC rule is implemented, because that's always what happens. As soon as there's a movement in this direction, some of those progressive states step up and do that. And of course, we've seen a lot of changes since COVID on non-compete state regulations and laws and statutes. So I anticipate that will happen. Now, we know there's a categorical ban in California, North Dakota, and Oklahoma. But some of those other progressive states that have strict limitations could go a step further. So states like Illinois, Massachusetts, New Jersey, New York, those are the ones to keep an eye on.
So that's interesting. So California is progressive, Oklahoma, North Dakota, not so much. How does that square?
Yeah, it is interesting. I have not researched the history of how those bans came about to know that, but that those are the states, and it is kind of interesting that those would be the ones. But I think right now we could expect more of leaning that direction from the progressive states.
I know that several states have banned it already, right? But the information that we get from some of the big companies who operate nationally, they make all their employees sign it, whether they're in a state. Is it enforceable? No. Is it a deterrent? Maybe, and that's why they do it. I'm not sure,
So actually, that's a great point, Dan, because this is now the time to really be careful with that kind of practice. Mm-hmm. Because the FTC feels that, that is, it is deterring employees from having the freedom and mobility to move, even if it's not enforced. And those large companies may have taken the position that we're going to have it, but we're not going to enforce it because we know we can't in certain states, or it's not structured to be enforced in certain states. So they're fine with just, the deterrent aspect of it. But that's where they need to be careful, because the FTC can pursue individual employers with non-competes. And they recently did that for the first time right before issuing this rule. So we know that they can do it and will do it. And so these employers need to ensure that any non-compete that they have is reasonably tailored to protect the company's legitimate interests, and that it doesn't exceed that, because I think they could become a target then for the FTC to investigate them. Right. So that's important. And in general, PMP should not overuse non-competes. You have to be careful with this. I think there's, it's sort of easy to just get an agreement off the internet and use it and not pay attention to what it might say and have everybody sign it. But really, non-competes should be reserved for positions that pose a competitive threat. And in the pest control industry, that's typically sales and management. They shouldn't, my opinion, there's not a great need to use them for positions other than those. So that's something to look at. The other thing that PMPs ought to do is really, take a look at what agreements they have on confidentiality, non-disclosure, non-solicitation. And if they want to protect proprietary information and solicitation of their employees after someone leaves, they need to ensure they've got good, strong, robust agreement that was developed specifically for their company in their jurisdiction, so that it could be enforced by the courts in their area. And that's where, again, a qualified attorney comes into play. This is not something you want to get from a friendly, PMP owner, or, like I said, off the internet. It's too much risk to implement something like that. And so be very careful, have those agreements reviewed now and make sure that they protect the company.
Okay. So yeah. So I think the main thing is get your stuff to an attorney, make sure that you're clean. And if not, then get there pretty quickly. And I mean, for me, just listening to you talk, it sounds like non-solicit's probably for technicians, people who are customer facing, and then non-competes or some sort of protection for managers and sales. Is that, I don't want to put words in your mouth there. And again, I know you're not an attorney. We do all the standard disclaimers, but is that a good summary or not really?
No, that's a good summary, but I think a confidentiality agreement is appropriate for any position that has access to customer information, customer lists. I think there's nothing wrong with a confidentiality agreement that prohibits workers who have that knowledge from disclosing that information after they leave.
It makes total sense.
Yeah. And to that end too, you really need to make sure that you have practices in place that send the message that the information is confidential.
Right.
Are you training employees on what confidential information is? Have you identified what confidential information is? Are new hires aware? And do you have practices in place to protect that information through your electronic systems? And rules about downloading, files and customer information. So those are all things that are part of this that you need to pay close attention to.
All right, I'm taking notes now.
Well, if sometimes calling lawyers to look at things that may happen can get kind of expensive. But you said that there's a 180-day grace period. Would you recommend contacting a lawyer today or waiting for the rule to go into effect?
Well, I would contact a lawyer today. That's a personal opinion. And the reason for that is, remember, we still have state limitations. So you want to be sure you're complying with those. The FTC is targeting individual businesses. So you want to be mindful of that, to your point about broad agreements or agreements used for everybody, whether or not they're enforced. And it's in your best interest to protect your confidential information now. Why would we wait to have a robust agreement for that? May need tweaking once, if the Workforce Mobility Act is passed, then maybe we need to tweak it a little bit. But I don't see why you'd want to wait.
Yep. Okay. Agreed. So you guys ready to switch gears? You want to talk about independent contractors?
Yeah, we can do that.
All right. So Jean, there's impending Department of Labor kind of a final rule pertaining to independent contractors. Can you give us kind of the same what you did before? Just give us kind of a background on this issue and what's going on.
Yeah, sure. In July of 2021, seems like forever ago, the Department of Labor issued a final rule on independent contractor status under the Fair Labor Standards Act. Now, remember, independent contractor status is defined differently under different employment regulations and under the IRS code. There's statutory employees, statutory non-employees. Under the IRS code, Dan certainly is the one to speak to that, not me. But I'm talking about the classification of an individual as an employee or contractor under the Fair Labor Standards Act. So in January of 2021, a rule was implemented, and it had been promulgated under the Trump era DOL, even though it was early in 2021 when President Biden was elected. And that rule was set to take effect in March of 2021. The current DOL under the current administration attempted to rescind it and stop it, but they were not successful. So it went in, it became effective in March of 2021. Unfortunately, that rule, which was very favorable for employers, some tests that were easy to understand for classifying workers, that rule is being rescinded in 2 months. And so I'll just mention very briefly, what's in effect today, as we sit here today, is a 2 core factor test for determining if a worker is an independent contractor or employee. And that 2 core factor test focuses on the nature and degree of the worker's control over the work and the worker's opportunity for profit and loss. So we boiled it down in 2021 to two core factors, and employers have loved this since then because it made it easy for them to determine if a worker was a contractor or an employee. Now, if there was disagreement on the end result of that analysis of those two core factors, then there were three additional factors that could have been utilized. Now, fast forward to now, the current administration believes that misclassification of workers as independent contractors and not employees is one of the most serious problems facing workers and businesses and the broader economy. So we have a philosophy again that they believe that this is bad for business, bad for employees. They feel like employees who are misclassified are denied basic employment rights like minimum wage, overtime, workers' compensation, unemployment. They can't participate in an employer's benefit plans, health insurance, retirement plans, what have you. And they feel like employers who follow the law are disadvantaged because they're going to pay more because they have all these labor costs that employers that don't follow the law and hire independent contractors they don't have those same costs. And I've heard that argument a lot, and there is certainly some truth to that. So the current administration is, again, very adamant about this, and to remedy the problem that made it easier to classify workers as contractors, last October 13th of 2022, they published a proposed rule to eliminate the two core factor test and to go back to a more ambiguous 6-factor test, similar to what was in effect prior to the change in 2021. So that proposed rule came out and the comment period has already closed. And we are now awaiting for the final rule, which will be published in May, according to the schedule, the Department of Labor schedule. So that's what we're looking at now. If it's published in its current form without significant changes, which I don't anticipate that there will be significant changes, then there will be these 6 factors. It's actually 7. This is kind of interesting. There are 6 factors, none of which prevail, none of which are considered core. They're all analyzed individually, and they look at the totality of the circumstances. But the 7th one is what's interesting and new and different. The Department of Labor has added a 7th test that is not defined. It basically is a possible factor that might be relevant to the determination, but they don't tell us what that is. So they left the door open to include other factors that nobody knows, what those will be. But the 6 core factors are again, similar to what we had in the past. It's looking at the worker's opportunity for profit and loss, depending on their level of managerial skill. They're looking at the capital investment made by the employee, the degree of permanence in the relationship between the worker and the employer, the nature and degree of control that the employer has over the employee, the extent to which the work performed is an integral part of the employer's business, and the skill and initiative. In other words, is the worker dependent on the employer for training and things like that? So it's I'm not going to say it's complex. I mean, it is. There's no way around it. It's going to take it's going to take some work to really determine if someone is legitimately an employee under the Fair Labor Standards Act or a contractor. It's a totality of the circumstances approach that we're going back to. So more litigation, more challenges on the horizon, but it's coming.
So just for context, as an employee, if you have a W-2 employee, the cost to have that W-2 employee, you've got to pay payroll taxes, you've got workers' comp, you've got state unemployment insurance, federal unemployment insurance. And, depending on what role that person is, that workers' comp could be pretty expensive. And so it could cost you maybe $1.15 to $1.20 for every dollar you spend, and so that's why an employer would want to have 1099 contractors. Usually young people who don't understand everything that they're entitled to also want to be 1099 contractors because they don't get any of that stuff withheld. But there's definitely, a little push and pull on that.
Yes. Mm-hmm.
Well, I was going to say, and we do. I am very aware of several segments in our industry that utilize 1099 contractors. And again, I realize we can put out all the legal disclaimers, but what should PMPs be doing about this this rule that's coming down? I mean, it sounds like this is probably going to happen. I mean, reverting back to something that was changed. I think that's probably going to happen, but what should they be doing now?
Yeah, I agree with you. It's probably going to happen. They need to get hold of these 6 factors. And they're published. They're out, in the public domain. It's just a matter of Googling it and getting the proposed rule. And when you get the proposed rule, I forget how many hundreds of pages it is, but the last 2 pages of the entire document have the 6 factors. So you just have to kind of flip through to the last 2 pages.
Of course,
you can see what those are. Yeah. And employers need to really look at those and review those with regard to the people they have classified as contractors. And determine, if in fact they do qualify to be classified that way. And there's more information about those 6 factors throughout the whole document, an explanation for each, if they care to go that deep. Or obviously they could hire someone, outsource the analysis of that and look at it. Now, but I also say that it's not just this FLSA, Fair Labor Standards Act proposed rule. There are other employment regulations and laws that define the employment relationship. So employers need to look at all of them and consider what would happen if they misclassified a worker under, another law. So we know IRS, it's about taxes. But there's other laws that come into play. So Title VII of the Civil Rights Act, the Americans with Disabilities Act. We have the Family and Medical Leave Act, which is enforced by the Department of Labor. So they're going to follow the economic realities test that I'm talking about, but there's other tests. So it's complex and employers need to pay attention to what the rules are in their state and under these federal employment laws.
And so who would they go how would they even know, like, okay, I'm in or I'm out? Is this an attorney? Is this someone like you? Like, what do I do? How do they figure out, like, okay, yeah, we're doing okay, or we're not doing okay as far as these 6 rules and the nebulous 7th?
So as far as these are concerned, they would want to talk to somebody who had a deep knowledge of employment regulations. We could certainly assist with that, or an attorney could assist with that as well. So gotcha. Either one.
Gotcha.
So we're starting to run short on time, but the last one that I wanted to cover, and it's really important, is the DOL's proposed rule to increase guaranteed salary level for white collar workers or white collar exempt employees. The reason that this is important is because so many people in our industry think that I'll just pay somebody a salary and I don't have to pay them overtime. Well, tell us about why this is so important and what the effect is going to be.
So this is really about overtime, and it's about the classification of a worker as exempt or non-exempt from overtime. And you're correct, Dan. So many employers believe that if they just pay a salary, then they don't have to pay overtime. But there are certain tests that have to be met for an employer to claim an overtime exemption for a given position. And what's at stake right now is something that we dealt with in 2016. And that is that the Department of Labor is going to be issuing a proposed rule in May that will increase the guaranteed salary level for a worker classified as exempt under the executive, administrative, or professional exemptions. So those are the white collar exemptions that you mentioned. So this does not affect 7I employees. This does not affect outside sales workers who are white collar workers, but they don't have to be paid a guaranteed salary. It only affects positions that are required to receive a guaranteed salary. Right now, that salary level is $35,000 $568. In 2016, there was a move to increase it. At that time, it was $23,660. So there was a move to increase it to $47,476. That rule was enjoined at the 11th hour, but the Trump era DOL came back in a year or so later and did increase it to the $35,568 level. So $684 a week. That is the current level. We believe that the proposed rule will increase the rate to at least the level that we saw in 2016. So at least 47,700 and 476, probably more along the lines of something in the $50,000 range. If that happens, when it happens, then PMPs will have a choice for employees who make less than that and who are classified as exempt. They will either have to increase the guaranteed salary level to retain the overtime exemption, or the individual won't qualify for the exemption and they will have to pay overtime. So that gets into all the pay plan issues. Do you pay bonuses and incentives on top of the guaranteed salary? How do you convert a salary to an hourly rate if the person is working 50 or 60 hours a week? And do I have to pay time and a half?
Why do you want to change me to a hourly when I was, oh my gosh, am I not good enough? It's a whole problem.
Yes.
It's a huge problem.
It is. Yeah. So it's going to have a significant impact, just like we were all dealing with in 2016. There was a lot of concern about it then. And those same concerns exist today. It's it's a concern. It's going to happen. Yeah. There will be an increase.
Yeah.
And frankly, I would tell you there needs to be. Okay. If you just think for a moment, the term executive, it's an executive exemption. What executive do you know who makes $36,000 a year?
Only at Donnie's place. But
oh gosh, no, Lord, no. No, not even close. But no, I agree. I mean, like you said, I don't know any executive that. You think about inflation. Well, it's just unrealistic.
It was a way to get around the overtime rules, but so very interesting. This is just terrific. This is good stuff.
I would agree. I would agree, Jean. It has been fantastic having you here. As always, I took a lot of notes. This episode as we were talking. I'm like, I don't know about this. So what we'll do is we'll put a link to your website. Just a reminder for those that are listening, all of the resources and topics that we talked about today are available on the podcast website, pmpindustryinsider.com. Just take a look under show notes. Jean, if it's okay, we'll put your contact information as well on that page, and we'll put we'll put some links in as best as we can. But I think the main thing is that folks know how to contact you. If it's okay, we'd like to put your info on there as well. And with that, Dan, anything else before we close out here?
No, I don't think so. I just want to thank you, Jean. It was terrific. It's always great to talk to you, and very, very interesting stuff. So.
Oh, thank you guys. It was great to see you. I appreciate the opportunity to talk with you.
Yep, that's good. All right. Well, hey, you all managed to spend another 40 minutes with Dan and I, but obviously the real star here was Jean. And with that, we're signing off. We'll see you all next time. Take care.
Take care. See you.
Bye now.
Bye-bye.